Hello, everyone. So we were discussing about the remarkable judgment, namely Nazrul Islam Majumdar versus Tahmin Akhtar alias Nahid and another, 47 DLR 1995, page 235. So in this case, it was about an amendment to plaint, uh, whereas, as you know, if the matters under the family court ordinance is before a family court, CPC does not apply. That is what we've seen from the plain reading of section 20 of the family court ordinance, from the judgments and jurisprudence of the courts, apex court of Bangladesh. So what happened was that in this case, the question was about amendment of plaint, and as you know that there is no provision of amendment of plaint under the family court ordinance. So the High Court division in the judgment did not precisely mention whether whole or how much of the Code of Civil Procedure will apply, but clearly expressed that it is discretion of the court to allow an amendment for ends of justice. This is what the amendment of plaint is a question. So the guiding principle for amendment to plaint is that it ought to be made for the purpose of determining the real question in controversy between the parties of any proceedings. And in the Code of Civil Procedure, I think we all have come across to this particular notion. Now, this was an issue. In the same year, in 1994, when another divisional bench of the High Court Division in Yunus Mia versus Abida Sultana Chanda uh, looked into the family court ordinance from a very broader perspective. So this is 47 DLR High Court Division 331, page number. So the case was against an order of a family court allowing the defendant to examine herself on commission as per the provision of Order 26 of the CPC, which on appeal was also affirmed by the learned district judge. So you all understand that when a Pardanishin Muslim lady who is not supposed to travel, is not supposed to go to the court, so there was a commission formed to facilitate her and to examine herself. So the court was in question that how within the family court ordinance application, when the family court ordinance is an exclusive uh, piece of legislations, how order 26 of CPC can come into the into can come into operation. So the court mentioned that it is a canon of interpretation that an attempt should be made to discover the true legislative intent by considering the relevant provision in the context of the whole statute. The court, so this is how the court is interpreting that a principle of interpretation is that an attempt should be made to discover the true legislative intent by considering the relevant provision in the context of the whole statute, and subsequently it considers that uh, the Code of Civil Procedure itself doesn't create any court, nor does define the word court. Its preamble says it is intended to regulate the procedure of the courts of civil judicature. So basically, the Code of Civil Procedure is a procedural law, and therefore there is no difficulty in its applications to proceedings of civil nature suits pending before the courts of any kind. So this is how the court interpreted. So I think the remarkable case is Yunus Mia versus Abida Sultana Chanda. Please remember this. Uh, the court is of the opinion that since civil code procedure is applicable to the court of civil nature, therefore there is no point of restricting the application of CPC to the present matter. Therefore, the bar in applying the code of civil procedure to the proceedings before the family courts imposed by section 20 of the ordinance is not and cannot be an absolute bar, but it must be a qualified and limited bar. Enactment of section 20 was only necessary due to certain procedures prescribed in the ordinance. The learned court finally held that only those provisions of the Code of Civil Procedure shall not apply to the family courts where alternative provisions have been prescribed for the family courts in the ordinance. So now I think in this judgment a different stand has been brought. And let me read again the part which has brought such stand. The learned court finally held that only those provisions of the Code of Civil Procedure shall not apply to the family court where alternative provisions have been prescribed for the family courts in the ordinance. So this is, I think, very clear. Now, if there are, for example, no provision related to amendment of a plaint, then certainly such cannot be an issue in the family court, isn't it? And again, when a suit or a dispute is brought is brought under the family court ordinance, it is understood that the family court has so many provisions. But again, when we are talking about plaint, section 6 of the family code, yes, prescribes about the plaint, but assuming that there is a situation where such a provision related to the amendment of plaint is not provided, so then what will happen? Certainly you have no option other than going through the CPC. So that is possible for application within the uh, family court ordinance, I mean the application of CPC. But the problem is that if you bring section 20, then it is quite clear that other than section 10 and 11 of CPC, other provisions are not applicable. Now, for a Polynesian woman, it is important that respecting whatever is her status is, the court should facilitate accordingly. So then the court actually followed Order 26 of CPC. Now, which is the whereas there is no such a mechanism available under the family court ordinance, and since the court followed that, I mean, one cannot deny the choice of the court, which is why the court can continue with it accordingly. So that's all, I guess. With respect to the application of CPC, clearly, as per the sections and case laws are concerned, only section 10 and 11 of CPC are applicable, others are not. However, there is a different jurisprudence developed in the case of Yunus Mia versus Abida Sultana Chanda, where the margin of the court and understanding is that if there is any issue mentioned in the family court ordinance, then CPC is not applicable, otherwise CPC is applicable. So again, we talked about the application of CPC because if such is an established principle, then certainly section 89A, 89C are some of the crucial issues which might come in the context of family court ordinance. If we assume that CPC is applicable, if that can be established, certainly mediation at the appellate stage, which is being dealt with in section 89C of CPC, are going to be applicable here. So that's one of the issue. which I think we should consider important. And as there are several interpretations provided that uh, uh, I mean, those interpretations provided that since civil judicature related matters, CPC is the procedural law. Certainly, it can be useful here. Otherwise, I mean, it should be useful here. So that is what they try to communicate. The law, the message under the law is quite clear. Mm, then yeah, there are many other issues. However, we don't see such issues being applicable in CPC. So yeah, thank you for this. And I think, yeah, once we discuss about the Muslim Family Law Ordinance, some of the other issues will also be clarified. Thank you very much.